Today is the Constitution Day, and therefore I thought it fit to talk about and discuss Article 14 of the Constitution of India, which I believe is one of the most important article, and it is the article which which goes which even though if you count the number of the words, it is the shortest article. It is one of the shortest article in the Constitution. But if you look at the impact it creates on the citizens of the India, then I would say that this article has the greatest weight and it is one of the most important article of the Constitution of India. Now, I will answer as to why I am saying so, as to this is the most important article. I'll discuss that in a bit of a detail. You see, Article 14, first of all, before I do the discussion or the analysis of Article 14, I must read out that Article 14 says that equality before law. So it says that the state shall not deny to any person equality before the law or the equal protection of the law within the territory of India. So if you look at the plain and simple words, it talks about the equality before the law and the equal protection of the law. But if we see how this particular article is developed over a period of time, then we'll realize that Honorable Supreme Court has taken recourse to this article again and again to impart justice to the citizen of India. So this is the most impactful article. This is an article which you see at the initial stage of the Constitution in the early just after the independence. This article was considered as an article to deal with the classification. So initially, the ambit of the article was considered to be that Article 14 of India is an article to ensure that the classification must not be arbitrary. That is the classification. If suppose two different group of citizens are given different rights or by virtue of the law, if certain restrictions are imposed on a particular group of person or a benefit is imparted to a particular group of person, then whether such a classification is valid or not. So only to determine whether the classification is valid or not, Article 14 was used. So it was said that the classification to distinguish two groups of people, when one group is either imparted some benefit or put at a disadvantage by virtue of some restriction imposed, then first of all, that classification must be founded on an intelligible differentia, which distinguishes those who are grouped together from others, and the differentia must have a rational relation to the object sought to be achieved by the act. So if any act is formulated by the parliament or the state legislature, and if two groups of people are treated differently, then what the article says that the Article 14 says that there must be equal protection of law and there must be equality before law. So on the basis of the bare reading of the article, initially the article was used only to find out whether any act is running foul to the Article 14 on the ground that the two class of people are treated unequally. And if they are treated unequally, then whether that act is valid in terms of Article 14. And in order to determine if suppose two groups of people are not treated equally, then the test laid down by the Honorable Supreme Court to determine whether that particular act treats two class of people equally or whether it is giving equal protection of law. The test was whether the classification is based on intelligible differentia and whether that differentia has a rational relation to the object sought to be achieved by the act. And therefore, Article 14 was considered to forbid class discrimination by conferring privileges or imposing liability upon person arbitrarily selected out of a large group of persons similarly situated in relation to the principal privileges sought to be conferred or the liabilities proposed to be imposed. But it does not forbid classification for the purpose of legislation, provided such classification is not arbitrary in selection of those group of people. So Article 14, to extend the discussion further, Article 14 prohibits under-inclusiveness as well as over-inclusiveness. An act is said to be under-inclusive when all those who are similarly situated are or they are not given a particular benefit or a particular burden is not imposed upon them. And where it is over-inclusive, where it includes not only those who are similarly situated with respect to that purpose, but others also who are not so similarly situated as well. So, an act may be struck down by the Honorable Supreme Court on the basis of a law being under-inclusive or over-inclusive. So, while the classification is permissible, so the first point is that the classification is permissible. That classification must be on intelligible differentia, and there must be a rational objective which must be sought to be achieved by that intelligible differentia. Now, intelligible differentia means something which is rational and justifiable. So, if two groups of people are, suppose, if I give you an example, an act gives a special privilege to a backward caste. Now, the privilege is granted because that caste is underdeveloped. Since the time immemorial, just because a particular group of people belongs to a particular caste, they have been discriminated against since ages. So a law is formulated to give certain benefit to certain class of, say, scheduled class. But within that scheduled class itself, suppose two class of people are similarly situated, but the law confers benefit upon one group of people, but it does not confer benefit on other group of people who are similarly situated. So that will be a classification which will not meet the test of intelligible differentia. Now, in this example itself, suppose it can be said to be under-inclusive. It will be said to be under-inclusive if similarly situated persons are not conferred the benefit. But suppose in the scheduled caste, some class of people who are not similarly situated, who are not scheduled caste, but they are also conferred benefit even though they are not underprivileged. So then it will be over-inclusive. So this is, you see, in a very rough manner, example of being under-inclusive and over-inclusive act, which may be struck down by the Honorable Supreme Court on the ground of not meeting the criteria of Article 14. But over a period of time, this Article 14 has been considered by the Honorable Supreme Court to be the founding faith of the Constitution. And the Honorable Supreme Court says, in the case of Maneka Gandhi versus Union of India, that it is the pillar on which rests securely the foundation of our democratic republic. So you can say, see how much importance the Honorable Supreme Court has considered to give to Article 14. So, therefore, Honorable Supreme Court in E.P. Royappa versus State of Tamil Nadu said that the ambit of Article 14 cannot be restricted to the issue of classification. It goes much beyond that. And if there is any arbitrariness in the state action, then that arbitrariness itself is a ground to strike down a law. So from the classification principle, that to test whether a law is meeting the test of classification, that is intelligent differentia, the Supreme Court moved a step ahead and said that if any state action, whether legislative action, whether administrative action, whether judicial action, if any state action is found to be foul to arbitrariness, then also that action is liable to be struck down. And the Supreme Court says that equality and arbitrariness are sworn enemies. One belongs to the rule of law, while the other to the whims and caprices of an absolute monarch. When an act is arbitrary, it is implicit in it that it is unequal, both according to political logic and constitutional law, and therefore it is violative of Article 14. Article 14 strikes at the arbitrariness in state action and ensures fairness and equality of treatment. The principle of reasonableness, which legally as well as philosophically is an essential element of equality or non-arbitrariness, provides Article 14 like a brooding omnipresence, and the procedure contemplated by Article 21 must answer the test of reasonableness in order to be conformity with Article 14. So an act must be just, right, and fair, and not arbitrary, fanciful, or oppressive. Otherwise, it will not be no procedure at all, and it will be against Article 14. So Article 14 strikes at arbitrariness in executive as well as administrative as well as legislative function. So if any act, whether it is executive act or whether it is a legislative act or whether it is a judicial act, if any authority while passing an order, whether in a taxation law or any other law, acts in an arbitrary manner, then it is liable to be set aside. For example, if there is a violation in the principle of natural justice, a fair hearing is not given, the documents on the basis of which a particular action is being taken, a so-called notice is issued, is not supplied, then that action itself is arbitrary and therefore it is liable to be set aside. So if any action which goes against the principle of natural justice, it will violate Article 14 because it will be an arbitrary action. So if anything is arbitrary, it is liable to be set aside. Now, I will refer to, now you must be wondering as to what is the meaning of arbitrariness, whether the court or the Honorable Supreme Court has defined what is arbitrariness. So then I would refer to the judgment of the Honorable Supreme Court in the case of Saira Banu versus Union of India, wherein this triple talaq was struck down. So Honorable Supreme Court defined manifest arbitrariness, and it said that manifest arbitrariness must be something done by the legislature capriciously, irrationally, and or without adequate determining principle. And also when something is done which is excessive and disproportionate, such legislation would be manifestly arbitrary. We are therefore of the view that the arbitrariness in the sense of manifest arbitrariness would negate legislation, and therefore it will violate Article 14. Now, after having discussed the concept of Article 14, its width and ambit, as we can see that if there is any unreasonableness, if there is any excessive or disproportionate law or action of the legislature or executive, if it is irrational, then it can be set aside under Article 14 by the Honorable Supreme Court. Now, I will discuss in the context of taxation laws, whether the tax laws can also be set aside on the ground of manifest arbitrariness or being arbitrary. Now, in this context, before I go on to discuss as to whether or when, under what circumstances the laws which are arbitrary laws have been struck down, I think I must refer to the judgment of the Honorable Supreme Court in the case of R.K. Garg versus Union of India, which is reported in 1981, Volume 4, Supreme Court Cases, page 675, wherein I think this is a constitutional bench judgment, and more often than not, this is the judgment which the revenue relies whenever we challenge any law before the High Court or Supreme Court on the ground of being arbitrary or finding foul of Article 14 of the Constitution of India. So it says that it is essential to keep in mind certain well-established principle of law while testing the validity of a constitutional validity of a law. That the first rule is that whenever that there is always a presumption in favor of the constitutionality of a statute, and the burden is upon him who attacks it to show that there has been a clear transgression of the constitutional principles. So burden is on the person who challenges a law to demonstrate that it is arbitrary. The rule is based on the assumption judicially recognized and accepted that the legislature understands and correctly appreciates the needs of its people. Its laws are directed to problem made manifest by experience, and its discrimination are based on adequate grounds. So just because apparently a law appears to be discriminatory, it cannot be struck down. The presumption of constitutionally is indeed so strong that in order to sustain it, the court may take into consideration matters of common knowledge, matters of common report, the history of the times, and may assume every state of facts which can be conceived existing at the time of legislature. Then with respect to economic and tax laws, it says that another rule of equal importance is that the laws relating to economic activities should be viewed with greater latitude than laws touching civil rights, such as freedom of speech and religion, etc. It has been said by no less a person than Holmes J. that the legislature should be allowed some play in the joints because it has to deal with complex problems which do not admit of solution through any doctrinaire or straitjacket formula. And this is particularly true in the case of legislation dealing with the economic matters, where having regard to the nature of problems required to be dealt with, greater play in the joints has to be allowed to the legislature. The court should be more inclined to give judicial deference to legislative judgment in the field of economic regulation than in other areas where the fundamental human rights are involved. So, the economic legislation or tax legislation are directed to practical problems And it may not be possible in the matters of the economics to strike down a law just because there is a possibility of abuse. Because a possibility of abuse cannot be a ground to invalidate legislation. And also, a legislation dealing with economic and tax laws may have some crudities and inequities in complicated experimental economic legislation, but on that account alone, it cannot be struck down as being invalid. It further says that every legislation, particularly in economic matters, is essentially empiric and is based on experimentation on what one may call trial and error method. Therefore, it cannot provide for all possible situations or anticipate all possible abuses. Now, I will discuss, even though this constitutional judgment bench is there, but despite that, there have been instances where tax laws have been either read down or struck down by the Honorable Supreme Court on the ground that it treats unequals equally or it treats equals unequally. One such example is the Constitution Bench judgment in the case of Kunathat Thate Huni Mopedal Nair versus State of Kerala, which has been reported in 1961, 3, volume 3, SCR, page 77, where you see there was a uniform tax which was levied on the land. Honorable Supreme Court struck down that particular law on the ground that a tax on land or a land revenue is assessed on the actual or potential productivity of the land sought to be taxed. In other words, the tax has reference to the income actually made or which could have been made with due diligence. Therefore, it is levied with due regard to the incidence of taxation. Under this act, since there is a uniform tax on the land, it is quite possible that out of land, because a land is arid, there is no income. Second case be where some crop could be raised, but there after employment of disproportionate large investment of labor and capital. A third one could be a kind of land where it just yield enough to pay for the incidental expenses and labor charges, besides land revenue and tax. The fourth is a kind of land which makes large profit because the land is fertile and capable of yielding good crops. And therefore, the fourth category of the land will be in a position to easily bear the burden of the tax. The third one may also be able to bear the tax. But the first and second category of land will have to pay from their own pockets if they could afford the tax. If they cannot afford the tax, then the property is liable to be sold in due process of law for the realization of the tax. Therefore, it was held that there is an inequality written large on the act, and this inequality is inherent in the very provision of the taxing provision. And therefore, it was held that there is no attempt made at classification in the provision of the act, and therefore it was struck down. Now, I will discuss the last judgment, then I will close. The judgment is the judgment of the Honorable Supreme Court in the case of Deputy Commissioner of Income Tax and another versus Pepsi Food. In this case, which is reported in 2021, volume 7, Supreme Court cases 413. In this particular case, the third proviso to section 254, subsection 2, capital A of the Income Tax Act was struck down on the ground that there was an automatic vacation of stay that was granted by the tribunal on completion of 365 days, irrespective of the fact whether, you see, if there is a delay beyond 365, if suppose stay is granted by the income tax tribunal, then section 254 subsection 2 capital A provided that there will be, if the stay has been granted, then after expiry of 365 days from the date of the granting of the stay, that stay will automatically expire. But it did not take into account whether the SSE, a particular SSE is there who is not responsible for the delay caused after filing of the appeal, where there may be an SSE who deliberately takes adjournment after adjournment, and therefore it is because of the fault of the SSE that the matter could not be decided between 365 days. So Honorable Supreme Court said that it fails to distinguish between two classes of people who are unequals. One who causes deliberate delay in passing of the judgment, and there is a class of person who does not contribute to the delay, are treated equally. So unequals are treated equally. So because unequal class of people have been treated equally, so therefore this particular provision was struck down. So friends, with this, I would like to conclude today's session by reiterating that Article 14 is one of the most important article to deal with any arbitrary or unreasonable action on part of the legislature or any executive or a state government employee or a central government employee. So if there is any arbitrary action by any of these executive or legislature, then the Honorable Supreme Court or a High Court will readily strike down such an action or such a law. Thank you very much. Yes, you are right. Madam Archana Bakshi is asking whether the entire discriminatory clause was struck down or was it altered to fix the lacuna. So effectively, obviously, it was altered to fix the lacuna, but because it was discriminatory, so therefore, the law as such became ineffective, because if after 365 days, if two classes of people are treated equally, then it will be very difficult on part of the tribunal to actually calculate the number of days because of which the delay has been caused, whether on account of the revenue and on account of the SSE, and obviously it was struck down. Thank you very much.